Hello, I'm George from Ireland. So this is more in contract law. This is about consideration. So, as the saying goes, consideration is the badge of enforceability in contracts. And in law, consideration doesn't bear the same significance that it does in English generally. So, significant consideration is something of value that an offeror and an offeree give each other. Okay, which could be an item, a service, money, and so forth, or indeed a promise to provide any of the foregoing. So this goes on every single time you purchase an item in a shop. Okay, there's executive consideration, which is a promise to do something in future, not giving you the money right now, not performing the service right now, not handing over the item on the spot. Now, some contracts are executory, which is to say it's an exchange of promises, and the actual consideration is handed over later, the service, the item, or the money. Okay, so now gifts are not legally binding unless put into a special form called a deed. You can see about that under Section 1 of the Law Property Miscellaneous Provisions Act 1989. So if I promise to give you a present and you're not giving any consideration, nothing in return, then that's not legally binding unless I write that on a form called a deed. So what is consideration? Well, Curie and Misa in 1875 set this out. So it said a valuable consideration in the sense of law may consist either in some right, interest, profit or benefit accruing to one party, or some forbearance, detriment, loss of responsibility given, suffered or undertaken by the other party. That's the end of the quotation. So doing something for somebody else, giving them money or giving them an item. But it could be promising not to do something that you have the right to do. Or to put up with something, that can be consideration, that I'm not going to take legal action against you, or I'm not going to disclose certain information. That could be consideration as well. Or I'm not going to establish a business wherever, or I'm not going to work in whatever sector, I'm not going to go to this place. That's consideration as well. So it might appear to be simple. So things can be performed to one party's detriment. So we talk about contracts which are executory. Okay, so more about consideration in contracts. So Cook and Wright, 1861, and the court established that enforceability of these promises is key to consideration. Or there's Simon Tobb and Chevalier, 2019. If a party says he's the right to sue, believes that he doesn't actually have that right, then that is not consideration for the promise made in return, because sometimes the contract, your forbearance is you're promising not to take legal action, even though they have the right to. Okay, so Wade and Simon, 1846 was a case which is about that as well, really. Okay, so we don't want to promote fraudulent behaviour. So if your consideration is you're giving up the right to sue when in fact you never had that right in the first instance, then that can't be consideration. So making a promise and performing a promise are not quite the same thing in law, but they both can be consideration. Lord Dunedin talked about this in a Dunlop Pneumatic Tyre Company against Selfridge and Co. Limited, 1915, a case about selling and reselling tyres. So there's an executory contract, i.e. it's been unperformed so far. One side makes a promise and there's a promise from the other side. So these promises are then enforceable because it's an exchange of promise. But this argument goes round and round in circles. So a promise is not to the detriment of the promisor and doesn't actually benefit the person who gets the promise if this promise cannot in fact be enforced. So it's only enforceable if it's a benefit to one party or a detriment to the other. But so there is this sort of reciprocal arrangement. So reciprocity is key to contracts, to consideration. There's got to be something in it for both sides. That's why there's a mutual exchange of promises. Well, that's a tautology, really. Okay, so consideration is critical here. Tweddle and Atkinson is a case about that. And it connects to privity. There's the old-fashioned word for privacy, like your privities with the private parts of your body. There's the Privy Council, that only those who are part of the contract can actually assert any rights under it. but we will come to how that principle is attenuated in recent decades. So another key principle is consideration must be sufficient, but it doesn't have to be adequate. Now, what does that mean? As in, there must be some consideration, however tiny, but it doesn't have to be a market value for what it is. A house worth £1 million can be sold for a penny if you wish. That is consideration. The court doesn't care that that's nowhere near market value, but you must have to give something. Could they argue that some consideration is de minimis? I'm not aware that they have thus far. Okay, so Thomas and Thomas in 1842, someone was going to pay £1 a year, even in the 1840s. That was a peppercorn rent, and that was considered enough to grant someone the right to live in the house. So a payment of cash is always consideration. It was a case called Chappell and Nestle, 1960, came before Lord Somerville, and he said a contracting party may contract for what consideration he chooses. That's the end of the quotation. So the judge was saying, you can sign a deal, even though it's a very bad deal for you, and just because you realise you've been foolish and agreed a bad deal, we're not going to let you get out of it on the basis that that's not real consideration. And Nestle, the company, the chocolate bar company, said, if you return us so many wrappers, we'll give you whatever prize. And so Chappell did so, and Nestle said, no, we're not going to give you the prize because that's not consideration. There's no contract here. These wrappers are useless. They're worthless. But the court said, no, that is valid consideration, so Nestle has to pay out. I mean, the idea of saying if you give us 100 wrappers or whatever, we'll give you some money, was to get people to buy more chocolate bars. Okay, so some things can't formulate consideration. For instance, in White and Blue at 1853, this son, he promised to stop moaning about how his father was going to divide up his property in his bequest. But the court held that that was not consideration. The son's promise to stop being a whingebag. Emotions can't be a consideration. You can't provide consideration by saying, I promise my love, or I'm going to be nice, or I'll hate that person. No, that's too vague. That's not something which is justiciable. Okay, so anyway, now things which are pre-existing obligations can sometimes be consideration. If you have an obligation to do something under law anyway, usually that's not consideration. Like if a doctor has to treat NHS patients anyway, or he gets his salary for that, and then he enters a contract with someone who's going to pay him money for treating the patients he's already going to treat anyway, well, that wouldn't be consideration, right? A teacher in a state school teaching his pupils anyway, and then someone says, well, I'll give you a car for teaching in that school. Well, that teacher in that school wouldn't be consideration because he's supposed to do it anyway. So obligations owed under a contract with a third party are not good consideration. Or indeed, performing an existing obligation in the same contract. It's only if you perform something above and beyond what you're already contracted to do. This could be good consideration. So some people have duties under law. Being a fireman, for instance, being a tax inspector. So that's not consideration for a new contract, the work you're already required to do anyway. However, if this public official does more than he was originally obligated to do, that can be good consideration. I mean, like to take on some extra hours or an extra difficult duty or something like that. Glassman Brothers Limited and Glamorgan County Council, 1925 is like that. Now, under the Police Act 1996, he says that the police, they perform their duty of preventing crime, detecting crime, and all the rest of it, maintaining public order, and so they can't charge for that. There was Leeds United Football Club against Chief Constable of West Yorkshire, 2013. Police had to provide security for football matches, and no, the police can't charge for that because that's their duty to maintain public order. Let me see. Then there are other things where there's an obligation which you already owe under another contract with another party, not someone party of the contract that's before the law. So now this can be a proper consideration for a new promise. For example, promising to wed someone. There was Shadwell and Shadwell in 1860. In those days, breach of promise of marriage was actionable. You might have seen Trial by Jury, that musical comedy by Gilbert and Sullivan, and there's that wonderful number at the end. And now, if you please, I'm ready to try this breach of promise of marriage, and so on. When I, good friends, was called to the bar and had an appetite fresh and hearty, I was, as many young barristers are, an impecunious party. I had a swallow-tail coat of a beautiful blue, and a ring like a ruby, and a something like a booby. I soon got tired of third-class journeys and dinners of bread and water, so I fell in love with a rich attorney's elderly, ugly daughter. The rich attorney said, "You'll soon get used to a looks head see, and she and a very good nice," said he, "a very nice girl you'll find her. She very well pass for 43 in the dusk with the light behind her. You shall reap the reward if you pluck my boy at the Bailey and Middlesex sessions." The rich attorney was as good as his word. The briefs came trooping gaily, and every day my voice was heard at sessions of ancient Bailey. All thieves who could my fees afford relied upon my orations, and many a burglar I've restored to his friends and his relations. So then I threw over the rich attorney's elderly, ugly daughter, and it goes on. So he promised to marry a rich barrister's daughter, who was considered well beyond marriageable age, just because she gave him an entree to these lucrative legal cases, because her father helped him out. And once his legal career was prospering, he decided to renege on his promise to enter wedded matrimony with this woman. Okay, so coming on to the Eurymedon in 1975, about this ship delivering goods from New Zealand. It's mainly treated as a privity case. This is about stevedores who load and unload ships. There was an obligation to carry these goods, but in a separate contract, but that was still regarded as valid consideration for a new contract. Or in this Pao On and Liao Yu Long, 1980, extraordinarily complicated Hong Kong case. So when somebody promised to carry out a duty that he already had under a separate contract, that was still proper consideration. Okay. There are obligations one might have under this contract that we're considering, and however, this can be consideration if you're just varying the contract, right? So let's look at performing an existing contract. There's Stilke Myrick, 1809. So in this case, there is a ship which is sailing, and the captain or whatever it is agrees to pay his sailors more. They've sailed out to sail back, all right, and they do sail back. And when they get there, he says, "Well, I'm not going to pay that extra money because you're only doing what you're already obligated to do anyway, which was to sail back home." So they didn't get any extra money because they hadn't provided any consideration. Anyway, there's another case called Williams against Roffey Brothers and Nichols Contractors Limited, 1991, about some carpenters renovating a house. All right. So then the carpenters found that it was going to take longer than they thought. It was going to be more difficult. So they were told, "Okay, we'll pay you more to do that work." The carpenters went on and completed the work, and then the carpenters were told, "Actually, we're not going to pay you more than we originally agreed, because what you're doing that carpentry work for us on this house. So that was only what you're obliged to do in the first instance. Therefore, you provided no additional consideration." Well, no consideration for this second contract. But anyway, that went to the Court of Appeal, and the Court of Appeal said that the carpenters would be able to get paid for that work that they'd done on the flats, and this is why, because when Lord Justice Glidewell held forth on this one, because they said practical benefits that had accrued to the defendants. Okay, what were the benefits for the defendants? The plaintiffs carry on the work and didn't pull out the contract before it was finished. There was a penalty clause that the defendants were going to have to pay some money if they didn't make sure the work was done on that block of flats, and it would have been a hassle for the defendants to find other carpenters at that time. So that's how it's different. There's another point in this case. The carpenters, they didn't put any sort of economic duress on the other party, nor did they mislead them in any way. So Stilken-Mirek is a little bit difficult. So anyway, so the Williams and Roffey principle will apply where there's a contract for goods or services. If a party is unable to perform the contract as originally envisioned, and that might be for financial reasons, if then the other party agrees to pay this party more, and the party who's agreeing to pay more will derive some real benefit from that. If the party that seeks more money, for instance, is not guilty of fraud or any sharp practice, okay, and if all the foregoing are fulfilled, then indeed that is real consideration. So anyway, Williams and Roffey, it seems that it might have affected that rule whereby part payment of a debt will not free you from the obligation to pay more of the debt, right? Okay, so let me see. There's other cases about this. There's MWB Business Exchange Limited and Rock against Rock Advertising Limited 2006. In that case, the Court of Appeal heard the case, and they said somebody who owns property and makes an oral agreement with the occupier who's not been paying as he should have done according to the original agreement can accept a late payment and can reschedule the additional payments. So the later agreement has given some practical benefit to the landowner, who has at least got back some of the rent that was owed to him, and that he didn't want the premises to be without a tenant because he'd be losing out. So here the contractor has promises to do less than he would originally, and the agreement to accept this payment is more or less the same as the Folks and Beer case 1884. So MWB is a bit of a breakthrough in the law. So anyway, remember in Williams and Roffey it was just about a promise. So this was good consideration to then go on to do what he was originally contracted to do. So the Court of Decisions, the Court of Appeals decision NWB went on to the Supreme Court. The Supreme Court upheld the decision of the Court of Appeal. Anyway, so Williams and Roffey, well, is a seminal case here. Now, some contracts have got a no oral modification clause or NOM clause. What's in the written contract is the contract. Anything we say doesn't change the contract, cannot possibly do so. So Lord Sumption, that celebrated medieval historian, Eldertonian, he said consideration is tricky, and more judges ought to look into whether there's consideration or not. Okay, so they've looked at this aspect of the law in other cases, such as Cavendish Square Holdings BV against Macdessi, or indeed Parking Eye and Beavis. So anyway, it's a very complicated issue in MWB. So courts will insist that a contract and term be upheld if it's about regulating how the contract is amended. Anyway, so let's look at part payment of debts. So go back to Folks and Beer 1884. So the rule is that paying part of your debt doesn't discharge you from paying the rest of the debt. However, certain things can discharge you from that if you paid ahead of schedule, or you paid in goods rather than cash. So then the whole debt can be written off. Similarly to Pendle's case in 1602. In Folks and Beer, someone was paid less than was owed, or paid it after the date it was due, and that's not consideration. Let me see. We can move on a little bit. So let's talk about past consideration, as in that's something that past consideration is something that you have already done. Can that be good consideration? Well, usually not. Okay, there was a case of Ray McCardle, 1951, where several siblings were living together. Now, McCardle did a lot of work, renovated the house, they lived shared with the sisters and brothers, and they had a beneficial interest. After the work was done, he said, "Will you please pay me something towards the cost of that work?" The siblings said yes, but then changed their mind and said that they wouldn't. And it went to court, and it was held that this was past consideration, that what he'd done couldn't be consideration. The contract was already finished when this supposed contract was formed, therefore there was no contract. All right, so there are some exceptions here. So looking back to that Pao On and Lau Yulong case in Hong Kong, Lord Scarman said there are three conditions here which would allow past consideration to be proper consideration. The first principle is that if the act, which is consideration, was done because the promisor asked it to be done. There's an instance of that in Lampley and Braithwaite, 1615. The second principle is that the parties realised the work had to be paid for somehow, in cash, in services, in forbearances, whatever. That's like Ray Casey's patents, 1892. And the third and final principle is that the promise would have been legally binding had it been made before the acts which are the consideration. Okay, so you need all three of those to be satisfied for this past consideration to operate. So that's unusual. The assumption is that past consideration doesn't count. There are some very rare exceptions. Okay, let's look at promissory estoppel, which is an equitable remedy. So you've already got a contract, and you talk about changing the contract you're already in. Parties can both agree to terminate this contract and make a new one. So that's varying it or modifying it if you wish. Many of the terms will be the same. It might change any one term of it, the price, the delivery date, or something. Okay, so that's a tricky way to look at it. So promissory estoppel, it was mainly about that Central London Property Trust Limited, but it wasn't entirely novel then. You can look back to Hughes and Metropolitan Railways, but it's moved on recently in Collier against P and MJ Wright Holdings Limited, 2007. But the High Trees House case is a classic one. So that is Denning, related Lord Denning, sat on this one, and he said it's all about a promise intended to be binding, intended to be acted upon, and in fact acted upon, is binding insofar as the terms properly apply. That's the end of the quotation. You can see my video outside at the actual High Trees House in Clapham Junction, London. Or there are other cases. There's estoppel by representation. This is estoppel arises because somebody said that something was a fact, and that made a promise in relation to the future. Jordan and Money is about that, an 1854 case. There's also the idea of waiver, and now common law recognizes that, and equity sees this as a way that they can suspend rights. Okay. Let me see. So what do we need to have for promissory estoppel? And there are restrictions upon the same. So if you look at MWE Business Exchange Limited and Rock Advertising Limited, 2006, Lord Justice Kitchen gave a very useful précis thereof. Anyway, so where was I? Okay, so this is a bit what Lord Justice Kitchen had to say. It seems to me that all of these cases are best understood as illustrations of the broad principle that if one party to a contract makes a promise to the other that his legal rights under the contract will not be enforced or will be suspended, and the other party relies in some way on that promise, whether by altering his position or in any other way, then the party who might otherwise enforce those rights will not be permitted to do so, where it be inequitable, having regard to all the circumstances. That's the end of the quotation. They often like to add that rider in law, having regard to all the circumstances. So anyway, so let's go through this slowly. What you need for promissory estoppel, you need a crystal clear promise. There must be no equivocation. Okay, as in Hughes and Metropolitan Railway, 1877, or as in Kim and Chasewood Park Residence, 2013, or in Closegate Hotel Development Durham Limited and McLean, 2013. Moreover, somebody has to rely on that said promise. Okay, as in High Trees House. So the lessees of that and the property, they believed that their rent was reduced by half. Great, and they acted in the faith of that promise. So anyway, incidentally, it actually doesn't have to be acting to one's detriment. There is W.J. Allen and Company against El Nasser, 1872. Okay, you simply have to rely on it. It might be to your detriment, it might not. It doesn't matter so long as it is relied upon. would go against conscience to allow someone to renege on his promise and get away with it, as per the Post Chaser, 1982. Another thing is promissory estoppel is a shield, not a sword. Okay, so this came out of Combe and Combe, 1851. This case, so a wife was trying to sue her ex-husband to get him to pay his alimony. Now she had not not alimony. Sorry, not it wasn't alimony. It was he had informally agreed to pay it, but she wasn't given any consideration. So this was under promissory estoppel. She won her case in first instance, but went to the Court of Appeal, and Lord Denning found against her, saying she provided no consideration. So that was different. Promissory estoppel couldn't be a cause of action. It could only be preventing what somebody else was doing, as in the High Trees House case, right? So it was the defendants were able to use as an advantage, not the claimant. Okay. And Denning said we still have to have consideration. As Lord Denning said, it remains a cardinal necessity of the formulation of a contract, though not of its modification or discharge. Discharge, say, I'll let you off the contract, or we both agree to end the contract. Okay, so there are other attempts where people have said, well, let's use promissory estoppel as a base of our action. Baird Textile Holdings Limited against Marks and Spencer PLC 2001, or in Australia, Walton Stores Interstate Limited and MAR 1988. But in Australia, they allowed it. Okay, another thing to do with promissory estoppel is the reason we have this doctrine of promissory estoppel is because it would be inequitable to permit the promisor to renege on his promise. Okay, that's a bit like waiver. So anyway, the judge will not always apply this principle, because as soon as we've shown that the promise modified the contract that was relied upon, the judge has a measure of discretion. Remember what Lord Kitchen said is having regard to the circumstances. So bearing in mind the situation in the round, you might decide, no, nevertheless, I will allow them to get away with breaking their promise. So if he's only going to stop the person breaking their promise if it will be inequitable to permit someone to break his promise and get off scot-free. Look at why the promise was made and what was offered and so on. There was D&C Builders against Rees 1966, where the builders promised to accept a part payment and then they would write off the rest of the debt for the work they had done. But this didn't lead to promissory estoppel because the debtor had really exploited his knowledge that the builders were desperate for cash, so would settle for less than they were actually owed. So that had to be improper. Let me see, in the Post-Chaser 1982, a promise was rescinded very quickly, and the other side didn't suffer any damage, even though they had relied upon that promise. In that case, it didn't go against conscience to allow the promisor to get away with breaking his promise. So remember, this is a suspensory doctrine in the main. You can modify a contract, and it's supported by consideration sometimes, and usually that's a permanent change to the contract. A promise might be time limited. And remember, in High Trees House, that reducing the rent was only for the period of the Second World War. Once the war was over, the rent was meant to go back up to its normal level. There was Tool Metal Manufacturing Company Limited against Tungsten Electric Company Limited 1955. So that's how it's suspensory. Okay, so that's just a little bit about promissory estoppel. Goodbye.